I mean, everybody has been sent it. Okay, we're live.
Okay.
Welcome everybody to the Senate Democratic Caucus. It's Groundhog's Day, and thank you, Senator McCormick, for reminding us of this important moment in our February lives. It's also the beginning of Black History Month, and today we're going to address the governor's executive order and what action is coming up on the floor. We're going to address our unemployment insurance bill and the breach, the data breach that has unfortunately happened with the Department of Labor with about 55,000 of their 1099 forms. So I think if, and then we will go around and update everybody on committees. The committee chairs will be updating people. Senator Sirotkin, are you ready to start with both an update on the UI bill and the data breach?
Yes, I think so.
Okay, great. And I would just refer, everybody has been sent the press release that the Department of Labor sent out. It's very good. It gives you, it'll reflect in large measure what Senator Sirotkin is about to share.
Okay. So we all learned yesterday about the so-called data breach where a lot of misinformation was sent out on 1099s having wrong names and addresses for people on the 1099 as to where they were sent. I guess the good news is there are 180,000 1099s that are supposed to go out, reflecting all the unemployment payments made in 2020. About 80,000 of them have been already mailed. The other 100,000 have been put on hold. So that's a bit of good news. A far smaller number of and we're not exactly sure, Senator Caucus said 55,000, involves some potential data breach. In other words, somebody got somebody else's number or social security number or amount. The bottom line here is that the department is moving in the direction of asking everybody to hold on to their 1099s that were issued mistakenly, and they say at this point they're going to ask them to mail them back to the department, which our committee raised some questions with, but and they're going to reissue new ones that will say corrected 1099 information on them. It's really hard. We spent 20 minutes, maybe more, with the commissioner this morning. We were not expecting to talk about this, but he showed up. He was there. I was kind of surprised. I thought he may be otherwise engaged, but he explained to us what was going on, and everything is pretty much in a state of flux right now as they learn more about the details and the extent of the problem and what they're going to do about it. The one major thing, in addition to if you hear from constituents telling them to hold on to these 1099s, new ones will be issued. You may want to tell them that they may be asked to send them back to the department, but I'm not sure I would even offer that information at this point. The one thing I think I and other committee members tried to express to the commissioner, please view this fix in the mindset of the recipient and the claimant, as well as any administrative mindset, any legal mindset, any financial mindset. Fully understand how this is going to be viewed by a great number of recipients, which is probably going to be confusion. That's why I'm not so sure it's a great idea to ask people to start sending these back. But there are questions of what they might inadvertently do with them if they don't destroy them or send them back. You can ask me questions. I'm not sure I have the answer. We were there for 20 minutes. there were, Senator Clarkson, do you want to add, I mean, the quicker you go into the weeds on this, the quicker you find out there are a lot of buts, not sure. It's just
Right.
very early in the stages. They're trying to figure out what happened. I mean, there is some talk already about doing an independent investigation as to why this happened. But we have very few answers at this point. So I would welcome Senator Ballin or Senator Clarkson adding to that, but maybe you can ask questions and we can try as best
Yeah,
we can to answer it.
there aren't too many answers yet, but they, you should, what's frustrating for them is that they had checked the data for, that it was accurate, but there something happened between the sending of that data and the coding to the house that printed and sent it out, and somewhere in there the data was pulled from the system inadvertently and was missorted, so the cells don't match, and it's a big challenge. We're very clear that whatever they send out next should be clearly say corrected and have tax information on it so that people know that this is new, this is corrected, and this is okay. So for the next 100,000 that go out, we will hope that there'll be clarity on that. But for right now, there aren't too many answers. We will give you answers as soon as we have them. We have time for just a couple questions. Do we have any questions right now?
Hardy, Senator Sears, and Senator Lyon. Senator Hardy.
Thank you, Senator Hooker. I was concerned because some of the statements to the press said that moving forward, they will take an abundance of caution to make sure they get this right. And that sort of implies that they were not using an abundance of caution to make sure they got it right the first time. But one of my also concerns, Senator Siraki, I don't know if you know, does this include payments that were made through the stimulus equity program? Because that is a program that we explicitly said needed to ensure confidentiality of information of the recipients of those payments. And I am really concerned if that has been breached, especially for that vulnerable population. Do you know if it includes them?
They are going to fix, it is, according to them, even though the lost wage assistance program is the primary victim here, they are going to fix it, again, in abundance of caution for all the programs, PUA, regular unemployment, extended benefits, every single unemployment check that went out during 2020. But it doesn't mean that they didn't do what you suggested. There may not be a problem with that particular population, but they're going to try and do a wholesale reissuing of the 1099s.
So at this point, they're not sure if those people were included in this breach, but they may have been, and they're going to fix it just in case.
Yes.
Yes. The two populations most affected were the Lost Wage Assistance Program and the Vermont Short-Term Supplemental. And also PUA is in that, but the two biggest populations they think are those two populations. And that's where the improper sorting occurred, they think.
But at this point, they're going to ask everybody, and again, I'm not sure it's the best strategy, to return whatever 1099s they get. And you can imagine what the return rate is going to be. I mean, a lot of people won't return it. So.
Right. So right now they're hoping everybody will hold on to it, and then they may give instructions for how to destroy it or whatever. I think more will follow on that.
Okay, Senator Sears, Senator Lyon, Senator Campion, and Senator Pearson, I believe. Okay,
and then I think we're going to need to move on after those.
Well, this is a serious breach.
Yeah.
I have a constituent, and I don't think we're treating it as seriously as it is. I have a constituent who contacted me early yesterday morning before I knew there had been a breach. And His concern was that he got somebody else's social security number. He got a mail addressed to him and his wife with the first names, wrong last names, wrong social security number. He opened it because we open mail without even looking at, who it's to. And he knows somebody's social security number and somebody has his. This is not, there should be an investigation. I don't know if it should be a legislative investigation or an investigation similar to the one we did with the South Burlington jail. But this is serious. And I think it borders on whoever's responsible needs to be held accountable. We can't keep doing this, folks. Now, I don't know how it happened, and we obviously don't at this point. But I don't think the solution is asking everybody to sit in the back and trusting everybody's. I mean, I think they have to put immediate hold on people's credit ratings and so forth.
Right.
I can see real problems here, and
So
I don't think we're treating it. I don't think the administration is treating it seriously enough. If this had been somebody else, the attorney general would be all over this company, whatever it might have been.
Yeah, we don't know all the details yet, but I didn't mention the fact that they are in contact with the attorney general. This is considered a formal breach. We have legislation in place as to what the responsibilities are when a breach like that occurs, including contacting credit agencies and giving people relief. You may have read in the paper that, they're talking about $7 million to fix this problem already. I share the concern, especially given, all the issues that have gone on with unemployment this year already. But it's just hard without, we got to wait to get a little bit more information to figure out what's going on. But yes, the attorney general has been contacted. Yes, they expect to be connecting with all the credit agencies on behalf of these people. But it's still very in the preliminary stage.
I think we should be calling for an investigation, independent, either that or by a Senate committee, one or the other. And if the Senate needs to, we should give that committee full subpoena power. But either way, probably simpler to call for an independent investigation. I'm not sure the attorney general's independent because he has to defend the state.
Senator,
I'm not necessarily, I'm not suggesting the attorney general do the investigation. I think the protocol and the statute, when you have a breach like this, is you have to notify the attorney general. And then, I don't know exactly all the steps that follow from there. I know there's credit agency connections that have to be cured, but we'll be, our committee is meeting with them again tomorrow. We'll certainly take these thoughts back to them and see where we go from there.
Appreciate that.
Thank you. Thank you.
Senator Lyons.
I think most of my questions have been answered, but I do want to reinforce the need for an investigation on this. My original thinking was AG's office, but I understand the need for independent. We have a list of all the people who were affected. That's a question. And so if all of those people are affected, can they be notified? Will they be notified directly? And then beyond the credit, freezing their credit rating, what else can be done to protect them in this period of time? This is ridiculous.
Okay. Senator Campion.
Yeah, I echo what everyone else has said. I really wasn't joking earlier before we started. This is such a serious issue, and people have been reaching out to me since 9:00 yesterday morning. And honestly, people need to know that the governor is working on this. And I wasn't joking when I said he's tweeting out pictures of pandas sliding. He should be tweeting out information so that people know what to do, where to get this information, what they need to do at this point. I would think this is an all hands on deck. This is one of the most serious things we're going to be dealing with.
Yep.
Senator Pearson.
I'd be very disappointed if they're not working on this nonstop as we speak. I'm actually curious what they said in the press conference this morning, if they have anything new. But tomorrow we will be having them in again.
My question is a suggestion, and it does seem far-fetched that people will mail it back, but since we have to mail everybody the corrected version, why don't we mail them, maybe suggest that they get mailed a pre-postage paid return envelope to make, to increase the chances. I mean, if we go from 30% get returned to 40%, that makes the system more secure.
They specifically said in an attempt to get these back, they will be sending prepaid postage envelopes. I don't know whether they'll be with the new 1099. I don't know when they're going to be coming or not, but at least they have done that. At least they have said they would do that.
Thank you.
Yeah. So I think given our time, unless there are any more questions, we are happy to continue to do this. Yeah.
Allison, it's Becca. I just want to say one thing, and you all know this, but I just want to be really clear. We have an important role to play right now in being the eyes and ears for our constituents. As much as you can take that information from the press release and anything that I send out to you this afternoon, please, as much as you can, turn it around into social media posts that can be shared in your communities, because as Senator Campion said, people need information in real time so that they know that we are on it. So be looking for more information as I have it in real time.
Yeah, thank you. And first and foremost, for people to hold on to them and not do anything with them at the moment is I think the first thing. But the press release it's got some helpful suggestions. And we will know more tomorrow. Thank you, everybody. Not what anyone involved in UI needed. It's really tough. It's lousy. I think Senator Sirotkin, if you want to segue into UI and what's expected this week on the floor.
The thing is, legislatively, we certainly have a vehicle. We're about to vote out a UI bill tomorrow that, I'll be brief, is an attempt to the continuation of the policies we put in place last May and June to liberalize both eligibility for the UI program for leaving your job or being laid off for COVID-related reasons, and also to relieve employers of chargeability for those kinds of claims. One of the interesting tweaks we're looking at, without going too far into detail, is to see how much of the requirement that a person who's who voluntarily leaves the job for health reasons related to COVID or childcare reasons, needs to be offered to be rehired in the job. And we're looking at that. It seems like at the very least, prospectively, we will be requiring that going forward, and that especially if there is a layoff by the employer due to shutting down and then reopening, the first person to get offered the job back should be the person who was drawing unemployment for those reasons. We were hoping to vote that out tomorrow and be up on the floor on Friday. We got a little delayed by this new development, so I don't know if we will get to it tomorrow to vote it out. We obviously have perhaps higher priorities, though that is also, it pales in comparison to what we're now dealing with, but it has some urgency because the sunset date for all these liberalizations is March 31st. And if we don't renew the policy from last year, even though the COVID virus is still with us, these remedial policies will sunset and people will not be able to get wage replacement for leaving because of COVID.
Thank you, Michael. Any questions for Michael on that? Okay, great. Then Senator Bray, would you be kind enough to update us on the executive order, the resolution that your committee is presenting? You're muted, Senator Bray.
Yes. How about now?
We can hear you loud and
Okay,
clear.
great. So the committee has taken several days testimony on the executive order that reorganizes district commissions and the Act 250 Natural Resources Board. In essence, moving applications from the 9 district commissions around the state to a central board, Montpelier-based board. And that board now currently has 1 full-time chair. And the proposal is to hire 2 more full-time board members onto that central panel, to add staff lawyers to support them and move, at least as defined in the EO, all the applications to that central new so-called professional board. It's unclear as to whether or not any work remains at the local level or not. So we took, testimony to look at how this might play out, and we had some concerns. We all know that Act 250 regularly brings forward calls for, a more efficient process or streamlining or greater transparency and efficiency. And we, agreed these are all agreeable things. The question was how to get there. As you know, when you get an executive order, it's a take it or leave it situation. The offer outlined in the executive order, we can only thumbs up, thumbs down. And as we looked at that executive order and took some testimony and discussed it, we found that we had concerns. So for instance, although the Natural Resources Board has been in existence for 17 years, it has never heard applications. That's never been one of its roles. That's always been at the district commission level. In terms that we heard about some challenging finances, they currently are running or were running a $647,000 deficit, which the administration proposes to backfill. And then on top of that, this new board, there were different estimates as low as $500,000 to stand up a new professional board, as high as $700,000. So there's quite a swing from being 647 into the red versus now running a new program that may consume as much into the black. So $1 million to $1.6 million, the swing there, with no explanation as to how that's going to be covered on an ongoing basis. There's just a one-time appropriation. There was concern about the costs for participants when you come into this higher priced form, panel, both, and also the loss of connection between local, literally neighbors serving on a district commission with whom you might have a more informal conversation locally, as opposed to the Montpelier-based professional board. There was no role specified in the executive order for the district commissions going forward. It's unclear what work, if any, they would do. There's unclear if there's a right of appeal for decisions made by the NRB, or if anything is still left for the district commission, if there'll be a right of appeal for that. And then the new professional board didn't have any provisions to address if there's someone on that panel and it's their brother-in-law that's coming forward with an application and they need to recuse themselves for potential conflict of interest, who's going to replace that person? So, we don't know if there's alternates, a process for choosing or assigning alternates. So these and other things came up, and it just told us that we were dealing with something that needed a valid concern, that needs further work. And the only way to really dig into that and work on it is in our regular legislative process. So we wrote a resolution that I would say, frankly, we tried to be as respectful and inviting as possible. And I'm going to pause and just read a little bit of it, because I don't know if people have actually read it. So whereas Senate Committee on Natural Resources and Energy has taken testimony and public comment concerning this executive order, and whereas the Senate agrees with the governor, it is to the benefit of the state of Vermont to maximize natural resource protections, enable well-planned growth, increase predictability, and reduce redundancy with other state regulatory programs, it finds complexities and possible unintended consequences that must be analyzed and addressed to achieve these goals. And whereas the Senate believes that the best mechanism both to resolve these complexities and unintended consequences and to explore in depth the options for reorganizing the Natural Resources Board is to use the standing committee process with the resulting opportunity for enhanced research, analysis, and public participation. And whereas the Senate is committed to working cooperatively with the administration to produce legislation that will achieve our shared goals of updating the Act 250 process. And whereas as the part of this process, Senate Natural Resources and Energy looks forward to reviewing and taking testimony in the administration's complete proposal for changing the Act 250 process, now therefore it be resolved that we disapprove, and further resolved that the Senate invites the administration to bring forward draft legislation to optimize the Act 250 permit and appeals process. So honestly, I think, if you support real Act 250 reform, I would suggest that people vote for the resolution and support at the same time in that resolution the committee's invitation to address this issue and others actually in an Act 250 bill that goes through and has the benefits of the full legislative process. So that's why the resolution is coming before the Senate, and that's our goal.
Thank you. And that is up for action tomorrow, right?
No, ma'am. It is.
It's on
It
notice
was
today.
introduced today, moved to the notice calendar for tomorrow, action on Thursday, Friday.
Okay.
It's treated like a regular bill, second and third
Right.
reading.
Thank you. Thank you. That's why we cover. Anybody have questions for Senator Bray at this point?
Senator Sears has a question.
My question isn't about the committee's decision. It's about Jay Johnson Pershing's position that both the House and the Senate need to reject the executive order. And I understand that there's been legislative council believes they don't. But if we pass this and the House refuses to take it up, will there then be a court challenge? Do you know what the next step would be?
Right. So it's a good question, and it's invites me to speculate. So you senators should probably notice this is not a joint resolution. So we are responding to the letter of the law just as a single chamber reading 3 VSA 2001-2 and writing our own resolution. How the House chooses to act, I don't know, and I'm not presuming to speak for them. If they were not to act and the governor decided this was not a valid response, the Legislative Council has told us we are in the right to stick to the letter of the law and send our own Senate response back. And to all the questions around constitutionality, we decided that we were not going to go down that road. We were going to stick to the bill and the merits, stick to the EO and the merits of the questions in front of us, respond to those alone. And the ball will be in the administration's court as to how they would respond to this if the Senate were to pass it.
I guess my question is, we're taking an action. It's not a joint resolution. The Senate's taking action. and I trust legislative counsel. However, the courts could choose to say that J. Pershing Johnson is right, and this proposal that you're rejecting would become the law, would it not?
We didn't.
I think you're taking a heck of a, all I'm going to say is I think you're taking a very big chance here that the Vermont Supreme Court or a court could rule that J. Johnson Pershing is correct. Put the Attorney General in an interesting position, who he had, but I think you're taking a real chance here. And so I just wanted to be aware of that as we go into it.
Right. Well, so we've listened to counsel and stuck with what seemed like the best course of action, which was to adhere as closely to possible to current law. I suppose you could say, well, you know this better than I do because you deal with the law so much and judiciary, but what a court would or would not do and when it might do it, we have no idea. So we're just, I'm going to sound a little old fashioned here. We took an oath of office to uphold the law. We read the law. Counsel told us what it meant. We're acting on that, and we're going to let the chips fall where they may if someone wants to bring suit.
I think I see Senator McDonald.
Senator, I appreciate Senator Sears' discussion on this. And one of the suggestions Senator Sears was perhaps making was that the House might wish to join us. And if we're the House to join us to reject the EO, I believe it would be an even more dangerous course, because that would suggest, when both bodies were to reject, that we agreed with the interpretation by Mr. Johnson, is it?
It's a miss or a miss.
Forgive me. We agreed with that interpretation. And when you look at the law calling for EOs, it is very clear that that law respects the Constitution that says for a law to pass, it must pass the House, the Senate, and be signed by the governor, or be the governor's veto being overridden. And no legislature in its right mind would pass a law that said if the governor and a single one body of the state were to be of one party, and the other house, the other body in the legislature would be of a different party, that this would permit governors every single year to put forward the EOs, and the opposition party would, when they objected, they would have, the objection would not stand for anything because of the notion that both bodies had to reject. An EO is designed for the situation where both the House and the Senate and the governor's office are in agreement of where the state ought to go. They've discussed it. They've come to consensus on it. And in the interests of moving things forward without unnecessary discussion, and I say unnecessary because it has been discussed and agreed upon, that this government can take advantage of that situation. Anyone who suggests that the legislature authorized the governor and one single party to move something forward in this by this method is misguided. I don't blame governor's office for saying there might providing us with an alternative fact, if you were. It's not so. So I would, that's my opinion, and I'm no lawyer.
Right. Anything else? Also, I don't think as we've dealt with executive orders in the past, I don't recall this both body requirement being raised.
Because there is none.
Right. I mean, we went through this with the merger of liquor and lottery and ACCD and the Department of Labor, and this was not an issue at all. And both of those were rejected. One, we went forward and actually merged liquor and lottery, but it needed more legislative work. But we ended up accomplishing the objective of one of those EOs. Anybody have anything further on this? I think we've given our time. We probably are not going to go and do an update. Is there anything that's pressing that people need to share that their committees are up to, or that you want to give us a heads up on that's coming down the pike? We have about 3 minutes before I know appropriations, and a couple others of you are starting at 1, but I know approps is starting at 1. Does anybody have?
Well, Allison, one quick note.
Yeah, sorry.
I know that thank you for the time to speak with the caucus here.
Yeah.
And I'm happy to follow up with anyone who has more questions or wants to discuss any of it. Thanks.
Great, thank you. And I obviously urge us all to read it. Anything that people need to discuss in the 3 minutes that we have left? Great, okay. Then I think let us finish today, and thank you very much. That was, and we'll more on the breach will come ASAP. And thank you all. This was good. Thank you very much.